So I'll just start over here. My name's Kirk Pendergrass. Been through the fire, going back to 1985, where I was the kid. I hate using the word child, and you'll learn why here, basically in a few minutes. Diction. But I've been through the fire. I've been to jail, been to prison, falsely accused or fraudulently through these bills of attainder, bills of pains and penalties. Been through the de facto kangaroo courts. I was kidnapped by the state of Washington CPS back in 1985. Went through foster care, running away, living on the streets, back and forth. So I've been through the fire. Again, spent 9 months in county jail for alleged felony driving without privileges, until the governor said, no, I'm vetoing that. And even the judge said, hey, I'm not sending you to prison because it's a victimless crime. Yeah, well, there is no victimless crime. No such thing. So we've all been taught wrong, right? Pretty much there isn't anybody alive today that's been taught the truth and real law, what your rights are, where they come from, and how to effectively defend them, or what I say, claim, exercise, and defend them. Now, there are many people out there who are quite knowledgeable on certain things, and they can lead you to believe that they know specific parts of the law and how to do certain things. And I'll give an example. We don't do motions, we make demands. That's false. Seventh Amendment, suits at common law exceeding the value of $20, the right to a trial by a jury shall remain preserved. No fact tried by a jury shall be heard, now pay attention, in any court of the United States, except for pursuant to the rules of the common law. This book, Common Law Pleading. Yes, there's a game that is played here. And I like to use reference to the game of tennis, because this is a very perfect analogy to associate what's really going on here. We're going to play a game of tennis. And who's on the court? There's two sides to the court, and we'll call this the court of record. Now, there's another part out there that talks about, oh, well, affidavit stands as truth in commerce. Yes, you're absolutely correct. But affidavits need to be in support of something. They don't necessarily just stand by themselves. That's not how that works. Again, back to the rules of the common law. And make no mistake, even the members of the bar learn common law pleadings and practice. Okay? Motion practice. In our motions, and in most every document that we file, when we're talking about moving the court of record, the court of record, court, is your documents. Now, there's a term out there known as sui juris. It's of lawful age, of sound mind, and perfectly capable of handling your administrative duties. Okay? The key part is administrative duties. Okay? I was in the Marine Corps. I was a unit diary clerk, 0131. I was the only man to touch the computer, which, back in 1990, 94, we didn't have Windows 95. So we were using, DOS 3.0. But I was the only man who touched the computer to enter information in. But we had to do paperwork. Everything is an administrative procedure or process, step by step. Paperwork. We have to create the court of record. So back to the court. The tennis court is the court of record. Who's on the court? You got one side and you got the other side. Now, this is the major misconception, that the judge is on the court. He is not. He's a referee. He's a disinterested third party, not having a financial or otherwise equitable or any interest in the matter before the court. The only time really that the judge should even be talking is if there's an objection. And really it's sustained or overruled. Now, they may ask back and forth particular questions, but when you make, either side makes an objection, everything stops. Now, this is on the record. This would be when you're present on the record. In the record is your documents. And you cannot talk about something on the record that is not in the record. That's a simple objection, attempting to enter facts on the record that are not in the court of record or in evidence, because your court of record is the evidence. Okay? So knowing this, performing your administrative duties if you're of sound mind and perfectly capable, right, of lawful age, and perfectly capable of handling your administrative duties. It is a duty. Make no mistake. You have to perform. Just like on the tennis court. If somebody hits the ball over to you, serves you the ball, which is served with paperwork. If you don't respond, silence is acquiescence, and there's a presumption in the paperwork in the court of record. Now, the judge is going to look at the court of record and assume what is in the record is true. So this is where we're getting into presumption and assumptions. Now back to the motion practice. Most of these documents at the bottom of them, like a petition to the legislature for the redress of grievances, key word, legislature, not the judicial. At the bottom portion of your documents is going to have a section called prayer for relief. Remember, we're dealing in the spiritual realm, really, honestly, because what we're doing is we're casting our spell. We're spelling this out. We are convicting the mind, the soul of any man who reads our paperwork. That's why it's called the court of record, in the spirit of the law. So in our prayer for relief, we're praying to God that we make sense, logic and reason here, to our fellow man, the party, our adversary, and we convince them, we cast our spell when they read our paperwork, convince their mind that either A, they're wrong, and we're right, supported by evidence, facts of law, actual facts, who did what, where, and when. This is where we make our demands for relief, and we have the right to demand this relief. Now we'll go with the word property. First, property is an aggregate of guaranteed rights. Our rights are our property. And that's why it's called a common law trespass. When they trespass upon our property and deprive, not violate, it's deprive. Deprive a fundamental right. Now we have three types of rights. We have natural rights, we have civil rights, and we have political rights. Now, not everybody has political rights. That's not inherent in man. Man has natural rights. In a civilized society, settled on the law, civilized as in we've agreed upon some sort of due process of law and an ideology, what's been settled. Society is those that are members or individuals. Those words, remember, jurisdiction. Diction is the words we use. Juris is a body of law. So when we say jurisdiction, we're talking about the words from a body of law. So when we say member, well, Article 6, Clause 3 talks about the members and shall be bound. Well, what are citizens? It's the Law of Nations, written by Emery Vattel, which is exactly where the part where it talks about in the Constitution about being a natural-born citizen in order to run for president, the office of president. Natural-born citizen is the definition coming from the Law of Nations written by Emery Vattel, Book 1, Chapter 19, Section 212. Citizens are those that are members of the society who are bound by it. So this is what our founders wrote in the Constitution because they read the Law of Nations. It was freshly out at that particular point in time. At least Book 3. There's 3 books there. So, let me look at your comments here real quick. Are you guys having a hard time hearing me, and is my microphone not picking up so well? Let me see if I can. How about now? Is that any better? How about now? Test, test. Turning it up.
Oh, good.
Okay. Oh, let's see.
I can hear you just fine.
Okay. Let's see, now I kind of forgot where I was left off there, but we're talking about diction, words we use as a body of law. And this is what I call the bar word salad. They use certain words to trap us, entrap. And it's fraud, it's trickery, it's a scheme, it's a scam, and it's a fraud. Yes, I know this. You should all know this. But the reality is we have to perform our administrative duties, or the record will be left unrebutted. The presumption in the court of record will be assumed by those that preside over it to grant relief. You have to make your demands for relief in proper form, or at least in a substantially proper form. Now, in document writing, there's a portion here that's called the caption. There is a caption portion of a document. Now let's see, how do I do this? Here, screen share. Okay. Move this over here. Won't let me. Okay, ready to see the screen?
Kind of.
That any better? Should be. It's showing full screen.
Sort of.
So this is the treatise on arrest and false imprisonment. I don't care how far down the road you are on studying law. I highly recommend this be a prerequisite #1 book to read. And I can put this, I'll throw this in there right now, if it'll let me with it being used. Okay, that's uploading into the chat there. I'm going to start with the basics of writing a document. Now, every jurisdiction, when we're talking about territorial or location jurisdiction, now they'll play the game with you. Oh, venue. Venue is the building. That's not the court. The court of record is your court. Okay. For those of you in Minnesota, you'll really enjoy this. This is known as the caption portion of a document. It's going to have, where it's at. That's the venue. Okay. Who the parties are. This is also known as the case style. Who the parties are. Who's on the court. Who's all playing in the game of tennis here. Now, some states use court file, case number, whatever. And again, this may be laid out, this caption portion of a document may be laid out differently in every state. So you'll have to figure out which, for those of you who've already gotten in some sort of entanglement with this fraud, you're going to have documentation that has the caption portion done. A lot of times you can go onto a website and download any kind of at least one document that will have the caption portion on it, so you can steal it from there. Now, back when I first started studying, this stuff wasn't on the internet. Internet wasn't even that much of a thing. Dial-up. I had to read it from the books, and I drew this out on paper. How our caption portion of a document is created, clear back in 1995, when I first started studying law, out of necessity. Because I'm like, I made a vow to God, a covenant, that I was going to start studying law so that I did not get screwed over again, not like that. And then the title of the document. Okay, and a lot of times they will tell you at the bottom of each page, the title of the document should be in this footnote part, right? Okay, now we'll get into who it's to and the body of the document. This is just standard format. This is the proper format of your document. Whatever it is, that's the body. Okay. Now we're going to get into, that's a summons. This one's the complaint. Okay. Plaintiff for his complaint against defendant. Da, da, da. Now notice these right here, and this is the most important part to learn, and those that talk about affidavits. Okay, this is it. Who did what, where, and when. Okay, so that's what an affidavit really is a statement of facts. Now, in this instance, now there are some other types of affidavits where you're making your own statements of facts, but at all times, your affidavits need to have short, clear, concise statements of facts. No fluff, no telling a story, just the facts, ma'am, just the facts. So for an example, on September 30th, 1992, plaintiff was traveling in his automobile on a public highway called between Richland and Minneapolis going northbound when stopped by the defendant acting as highway patrolman and an employee of the state of Minnesota. Okay, short, clear, concise statement of facts. Now, what I've recommended to people in the past and over the time now is, go ahead, write your story out. I mean, I've heard thousands of stories over the last, 8 years of doing this now. People, just write it out. And I think that's the best way to do it to start with. Write out your whole story, because it seems that people can write their story out and send it to me in an email, but they can't figure out how to put that same stuff in the form of an affidavit in a statements of facts. But that's the number one thing to do. And part of it is you grab your paperwork and your evidence, put it in a chronological order of things, and you can even pull directly from your paperwork, one page at a time, and make your statements of facts based on the paperwork in the court of record. So these are all statements of facts. And some of you may be familiar with this little format, how they do their little statements of facts and when they file a complaint against us. But notice what the law that he is citing here under the counts. Minnesota Constitution, Article 1, Section 7. That is a declaration of rights. Rights are the law. That's right. Rights and law are synonymous and comes from the French word droit. So now that we all know that the rights are actually the law, especially when we're talking about natural rights and even civil rights, because law is that which is laid down, ordained, or established. So declarations lay down the law. Declare. Down, clarifying by writing it down. So at law, at common law, this is how it's done. We declare things. This is over here on Telegram, Baba. This is for COVID mandates, restrictions, loss of employment, EDC. This is for everything. This is at the root of everything. I don't care what it is. This is pursuant to the rules of the common law. Okay? This is just how things are done. How we're supposed to be performing our administrative duties is doing the paperwork. So, now that we know the common law is the law that is common to all, it is all of our rights that are common to all, because God created mankind. What kind of man are you? Are you a man or a man with a womb? Womb man. So for those out there that are having a hard time comprehending what a woman is, I'm not a biologist. I can't define what a woman is. It's in the word. Words have meanings. And in the English language, we have lots of words that have phrases behind it, what's known as pronouns. Imagine they would use, well, what's my pronoun? Yeah. Pronouns is a word that's made up of made from phrases. And I'll give you an example. Attorney. Attorney is attorn ye. To attorn you. To attorn your fellow man. Which we have the right to do. Wisconsin Constitution, Article 1, Declaration of Rights, Section 21. We all have the right to prosecute our own claims. Oh, an attorney is a prosecutor. Doesn't have anything to do with the bar. We all have the right to be an attorney. Why do we have power of an attorney, a durable power of an attorney? In fact, because we have the right to the assistance of counsel, and that assistance of counsel is our choice. It's our friend, who might be a little more knowledgeable than you, or myself, right? I can enlist my friend to help me out. We have that right. And the government doesn't have any authority over who our choice is. And there's no such thing as a license to practice law. Because, well, if we're going to claim God's law, you can't license the practice of law. But what they're doing is their code. This is code practice, code pleading. Okay? Oh, here it is. Yes, I have many, 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 many books. I happen to have here Hornbook series, Clark on code pleading. Okay? They moved away from the common law pleading to code pleading. But make no mistake, it's just an overlay, because we can't get away from the rules of the common law, pleadings, and practice. So what they're doing is their choice of law, the body of law, not the documents, not the rules of procedure, but the body of law. So this is known as choice of law and choice of jurisdiction. kind of one and the same, really. But their choice of law for Idaho, they used the Idaho Code. Well, that's not law. See Peterson versus Peterson, Idaho Supreme Court, Judge Eisman, 2014. The Idaho Code is not the law because the Code Commission has no legislative authority. Huh. So how would we object to that? I'll get to that. This is part of how to perform your administrative duties and effectively defend yourself by doing the paperwork. Okay? So, what law is he citing here? He's citing rights. His rights were trespassed. Okay? Now these are document templates right here. Now this is for you, the maxim of law here is that the defendant by pleading or exception becomes the plaintiff. So you have to make a pleading and you have to take exception. I object to this. I rebut your presumptions. Okay? So the way this is supposed to be done, the number one document is called a notice of special appearance. All right. So let's take a look at something. I'm going to go to my... Now, people ask all the time, well, where do I find these common law rules of procedure? Well, you kind of have to read between the lines, but they're right here. Right here. Now, they hide this because this is the trickery. Technically speaking, we would have crimes as public offenses that would apply to public servants, those in the public, not the general public. This is trickery, right? Man is in the private. Man is not a member or an individual of the society unless he is bound by it. Are you bound by the Constitution? Then you can't be bound by anything created under it, unless by and through a contract. Yes, there shall be no law impairing the obligations of a contract. The exception to that rule of law is fraud, because fraud vitiates everything from its inception, void ab initio, which also invalidates and makes void the birth certificate, the social security number, your driver's license, your whole banking. That's all fraud. Now, does any man have to actively engage in the fraud to get out of the fraud? No. When fraud vitiates everything from its inception, void ab initio, we're done. And any man who takes action under that fraud becomes culpable. That's a fact. Okay? But it's about learning how to assert your claims and effectively defend yourself. Okay?
Kirk, could I ask you a quick question?
Sure. Go ahead.
These templates, are they in the book that you were just describing?
Yes. That's right straight from Treatise on Arrest and False Imprisonment.
Perfect, thank you. Sorry to interrupt.
Yeah. Okay, so going back to the rules here, and what they've done is they've and I have found this in my 11th session, legislative session of the Territory of Idaho, before we had the Constitution. This was 1881. What a coincidence. The statutes of England, now for those of you that may or may not be aware of what happened with the Reconstruction Acts of 1871, everything was given in trust to England, back to England. Technically speaking, the Civil War was not necessarily about slavery as so much as it was enslaving all of mankind. This has been in the works for a very long time. This New World Order, one world government. It's Catholicism, and which is nothing but Islam in disguise. And I've already exposed this. Have for years now. But what they've done here in Idaho even, that is Code of Civil Procedure, which comes from the High Court of Admiralty of England from the statutory law of 1881. What a coincidence, eh? They've combined public offenses with the common law. No, there has to be a separation. But that would be subjecting us to those pretended acts of legislation that the Declaration of Independence talks about. Okay? So we have to have a little bit of discernment here and read the rules of procedure. Because the common law rules of procedure are in fact in these rules of procedure. They are there. But they've split them all up, right? Because suits at common law can be criminal in nature or civil in nature.
Did you freeze?
Okay, I see your comment here, but that's what this video is going to be about. That's what this meeting is about. Is for you to learn how to effectively defend yourself. So I know that those of you that are just now joining didn't get the very beginning part, and I'm recording this and I'll upload it up here, okay? So you can come back and watch it again later. So we're talking about rules of procedure from the common law. And again, how they've basically just, that's why we call it the word salad shooter, is they put all this stuff into the salad shooter and they crank it up, and this is the bar, and they spit out all these different words and jurisdiction and all this stuff, and it's to deceive man. These are deceivers of men, make no mistake. And what I want people to comprehend here is that we're at war. The court is a battlefield. If you do not have the knowledge, you have no power. You know, the Bible talks about how the tongue is sharper than a double-edged sword. Can I get any volunteers to stand here and let me swing my double-edged sword at them? Imagine what it would do to man's body. Now think about that as speaking the law. And this goes back to the other known term as lawyer. One who is knowledgeable on the law, one who speaks the law, is a law-sayer. Lawyer is a pronoun. It has all of those phrases make up the word lawyer. Yer, to speak. Speak the law. We do not have to be a member of the bar in order to speak the law. So what we have here on the court is we have a prosecuting attorney and a defense lawyer. Okay? So in order to remove those presumptions, this is how it starts. The very first document. Now, this is where you're the defendant. But see, through all of this, I'm invoking the maxim of law, which is the defendant, by pleading or exception, becomes the plaintiff. Now, the treatise on arrest and false imprisonment there shows you how to become the plaintiff. Okay? So I'm going to go to the rules of civil procedure, where they hide this notice of appearance. Now, there was a gentleman in here who talks about, oh, I filed an affidavit and they didn't respond and they didn't want to let me talk about it. That's because it wasn't accompanied with the proper document. You got to have something to move the court. And you had stated that you'd had an attorney. Now, I'm speaking from experience here because in my family court case, okay, I basically defeated the judge's own contempt of court for not going to the parenting class, and I made the argument that it deprived me of my life, my liberty, and my property. Because one, on the grounds of life, is it deprives me of my life, my education, and what I choose to put in my mind as knowledge. I'm being brainwashed by these people, and it deprives me of my life. The second part is liberty, because I claim now you're saying that I have to go incarcerate myself, deprive myself of liberty, and be brainwashed by these people. Then the third claim was property, because saying, well, I have to pay $50 to go incarcerate myself to get brainwashed by these people. So there's three separate grounds for dismissal right there. deprivation of the right of life, deprivation of the right of liberty, and deprivation of the right of property without due process of law. You did not get consent of a jury, and you didn't get my consent. So you have no lawful authority to dictate to me what I do and how I do it and what my education is unless I consent. So, with my attorney, my member of the bar there, sitting next to me, and this guy's pretty well known here in our area for years, supposed to be one of the better ones. That was the last time I've ever hired a member of the bar. And when I told him this before we walked in, he's like, well, I'm going to let you speak because, I blah, 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 blah. And what's he do right afterwards? And the judge dismissed the contempt of court. And this was beautiful, folks, because the courtroom was packed. I mean, it was packed. There's people standing over on the side and the back. It was so packed. And because I had a member of the bar, I was the second one up. Because, they always take those members of the bar, clients that have members of the bar first. Because they're on the clock, getting paid, billable hours. And when we got up there, he's like, well, Judge, I'm going to let him talk because, he knows what he wants to say. And the judge is like, what's going on here? Are you sure? Yeah, I'm going to let him talk. Okay, so I did my spew, and one time she's like, well, I think I'm just going to go ahead and find you guilty of contempt. And I'm like, no. Jurisdiction here. And again, I'm claiming deprivation of rights. Where's the rebuttal? But see, the judge can't testify from the bench. She has to take the stand to testify. So quite a conundrum, because there's no prosecuting attorney over there. This is the judge's own contempt of court. Kind of hard to get off the bench and take the stand to testify. So then the second time she went to go, I said, well, wait, we haven't even gotten to jurisdiction yet. And that's when she was like, you know what, I think I'm going to go ahead and dismiss this. It was the best thing she could have done. And she admitted it later when I came back in front of her for after my attorney filed the paperwork and said, I want to be relieved of the duties to perform here because he's asking me to make this isn't constitutional law. This is the common law, real law, rights as the law, not color of law, statutes, rules of procedure, and regulations, city ordinances. No, that's color of law. That's man-made stuff. This is God's law from the law of nature, which is also what the law of nations, the title of the book is Law of Nations, or the Principles of the Law of Nature. Fundamentally and principally, this is at the root of all law. Because God is the one who created all things. And the maxim of law is, the law speaks to all with one mouth. Guess whose mouth that was? That would be God's mouth, because he spoke everything into being. And God gave man dominion over the land, the air, and the water, but not over other men. We're all free dominion. We're equal. And we have the right of conscience. Okay, this is so important to comprehend this. I think. We have the right to think for ourselves. This is another word, that diction. Okay? And it's not law common to I. Okay? It's common to man. The I is this all-seeing I. It's all trickery. You really need to be careful with the words that we use. So, he does all this paperwork, judge relieves him. And I come back into court, and the judge tells me, well, I don't have a notice of appearance from you. I don't know who you are, and you can't speak until you do. Because the court of record is deficient with identifying my status. Who am I? How am I appearing? Now this debunks the whole concept of changing your status. Now keep in mind, when we're talking land, air, and water, it's law of the land, law of the air, law of the water, which again comes from God because he spoke it all into being. Now, it depends on your locus, location, jurisdiction, territorial jurisdiction, which one you're in, and the words that you use. So, we have to do this paperwork. And she's telling me, okay, you can go down to the court assistance office and then get these. They have document templates there, if you're here, us here in Idaho, for these document templates, a notice of appearance. And so I'm like, okay, but you need to go down. Then she looks at the clock, says, oh, you can't make it down there today. She's like, you've got 1 day, a window of opportunity. And, basically she was testing me to see if I really want to follow the rules, follow the law. Okay, so I had to do this. Go down there and get this paperwork and get it in and submit it. And, she was like, need a motion for continuance, motion to shorten time to hear the motion for continuance. She was nice. She laid this all out and basically was testing me to see if I really wanted to do this, right? If I was capable, right? To see if I'm perfectly capable of handling my administrative duties. So I did it. I showed up at 8 o'clock, Johnny on the spot. Got the paperwork, did the paperwork, got it filed, got it served. We came back in 2 days later. She's like, yep, you did the paperwork that I asked you to do. We're good. Now, when we're going to challenge jurisdiction. Now, if you do not do a notice of appearance, it will automatically, by default, because it's your own fault for not performing your administrative duties. Now, again, I want to reiterate that the civil rules of procedure, the criminal rules of procedure, while they will say, oh, well, you're citing a civil rule of procedure. Well, don't cite it. These rules of procedure are not law. And people ask all the time, well, where can I find these rules of procedure of the common law? It's supposed to be common sense. But this is the trickery, the scheme, scam, and fraud. They're trying to hide it from you. Now, there are two types of appearances. General appearance or special appearance. Okay? Idaho Rule Civil Procedure Rule 4.1, General or Special Appearance. Forget the rule. Let's look at what it is. Because the first fundamental principle of due process of law is notice and opportunity. Now, to respond, to rebut, whatever. The fact is, silence is acquiescence, correct? We all can agree on that. So, you've been served with paperwork. Did you respond? Well, I filed an affidavit. No. Did you properly respond? No, you didn't. Because this is the first document. This is your status. You don't need to change your status to anything. I am man, creation of God. I challenge any man out there right here, right now, anytime, to rebut that and provide evidence to support the claim to the contrary. You will lose that argument. Every time. Prima facie. God created all mankind. How do you rebut that? Can you prove that God isn't the creator? Fundamentally and principally, evolution evolved from what? Something has to be created first to evolve from. So how did it get created without a creator? This goes to the word sovereign. Creator is sovereign. Like when we talk about mother and father. Okay, diction here, proper words. Not parent and child, because that comes from old Roman civil law from 600 AD. Parens patriae. The state is the parent. Ah, weird. Yeah. So proper diction is mother and father because that's God's law of nature. And it's son and daughter, which is our estate, our chattel, our property. Now, in order to deprive property in these fundamental rights, you have to follow due process of law, which comes again from the common law of the land. And if they don't, that's a deprivation of the right to due process of law. That's a grounds for dismissal. Do you know how to assert those grounds? You got to do this first. This is the first document. General appearance, the voluntary appearance of a party or service of any pleading by the party, except, here's the exception to the rule, as provided in subsection B of this rule, constitutes voluntary submission to the personal jurisdiction of the court. Okay, they've served you with paperwork, and if you don't respond and give notice that you're objecting to the presumption of the other party, because you've been served the ball is now in your court. You have to hit the ball back, or that's a default. Right? So, motion or special appearance to contest personal jurisdiction. The following do not constitute a voluntary appearance by a party under this rule. A motion or Rule 12b, 2, 4, and 5. We'll go to that. Whether raised, now pay attention here, whether raised before or after judgment, because jurisdiction could be challenged at any time, because fraud vitiates everything from its inception, void ab initio. But in the interim right here, the judge will assume jurisdiction if there's nothing in the court of record to object. There's no objection here without this objection. Motion of Rule 40A&B, motion for extension of time to answer, otherwise appear. Okay, this is exactly what I experienced in the family law court, which is where I learned about this notice of special appearance, aside from what I learned from Carl Miller back in 2012. He talks about doing a notice of appearance objecting to the personal jurisdiction and filing a motion to dismiss. Because this is how it's done, folks. This is the game of tennis from the rules of the common law. You might be unlawfully dragged into this, but it's up to you to defend yourself. I mean, try stepping into a boxing ring, forced into the boxing ring. Are you going to defend yourself, or are you just going to stand there and let them beat you up? Somebody ought to do something about that. Be a somebody. Knowledge is power. You don't have this knowledge, you ain't got no power. You're not going to be able to defend yourself. You're going to get the crap beat out of you. Hey, please mute yourself over there. The joinder of other defenses in a motion under Rule 12b, 2, 4, and 5. Any kind of joinders going on? A response to discovery or to a motion filed by another party after party files a motion under Rule 12. Keep going back to that Rule 12b, 2, 4, and 5. I'm going to go over there in a minute. Action taken by that party in responding to discovery or to a motion filed by another party. Pleading further and defending an action by a party whose motion or Rule 12b, 2, 4, and 5 is denied. Doesn't matter if they deny it or not. Now, here's the or. Here we go. Filing a document entitled Special Appearance. In quotations, they're telling you right here the title of the document, which does not seek relief. It's a notice. Right? Watch. Which does not seek, but merely provides notice that the party is entering a special appearance to contest personal jurisdiction. If a motion of Rule 12b, 2, 4, and 5 is filed within 14 days after filing the special appearance, or within such later time as the court permits, the court of record, I don't need their permission to exercise any of my rights. I put them on notice. That's sufficient to put them on notice. Now, what I do is, because I know that affidavits are supposed to be in support of some document. Notice of special appearance objecting to the personal jurisdiction, an affidavit in support of that motion. Here's my affidavit. Okay. Things like, hey, I am not that name in all capital letters. Now the one I've got actually came from a book, but I've used it and put it in the record in the cases that I have going on right now. And they're crapping their pants because they know, and I've reiterated it. Okay, I've shared that video in the Telegram channel there of the court hearing on that, where I brought it up. Well, I previously filed a notice of special appearance objecting to the personal jurisdiction here. Jurisdiction is in fact being challenged. But I haven't done the actual challenge yet. I didn't do that within 14 days because what I'm doing here specifically in these cases is I'm exposing all the fraud and trying to take it all down because I now possess enough knowledge, I think, to take this all down for everybody. If it were just me wanting to effectively defend myself and be done, I would do this process, which I have previously done. And there's somebody in here right now that has actually taken my document templates that were actually set up for Minnesota, how convenient, and used them with her sister. And, well, the first documents got messed up, and the court didn't respond, the court ignored it, redid the paperwork back to the way I had it, resubmitted. 2 days later, the court calls and says, hey, Mom, go pick up your kids. I vacated your entire case. That's because the paperwork was done properly, asserted the proper grounds for dismissal, challenging jurisdiction. And the judge read it and went, there's no way he can even rebut it. So once he's been put on notice, he has to ensure justice. Now, if they don't, they deny, right? Like it says, or is denied, doesn't matter. It can be challenged at any time. And you're creating your court of record, the evidence. So, again, going back to keep calm, stay calm, learn to play the game and learn that these people over here are evil. And they're going to deny. They play the game of we're going to do whatever we want to do. Catch me if you can. And that's what I'm trying to teach is how to catch them. But you have to create your record first, because how are you going to have evidence that you gave notice, that you afforded them the opportunity, that you followed due process of law? Well, they deprived me of my rights. They violated my rights. No, it's deprived. Yeah, but just because they're depriving you of the right to due process of law does not exclude you from following due process of law. You have to remain in honor. Turn the other cheek and give notice. Afford them the opportunity to respond. If they don't and they continue on with their fraud, they become culpable. But stay focused on what you're doing here. You're creating your record, your evidence, your paper trail, your transactions, occurrences, and events. Yeah, no assumptions here. We all know about assume. No, you have to, we have to perform our administrative duties, or you're incompetent, which is why they say that you're a ward of the court and you need to be represented, because you are not sui juris. You're not of sound mind because you don't have the knowledge. And I've been there. There's reason why I am where I am today, because I made that vow to God that I would start studying so that I do not get screwed like this again. And then it's turned into, hey, my fellow man needs to get educated. This is not legal advice. This is education. I can only lead you to the water. It's up to you to drink it. I can only lead you to the knowledge. It's up to you to put it in there. Okay, so now that we know about how to appear, whether generally or specially, that's your two options. And if you fail to file this, it will automatically default what's called latches. Latches occurs when you fail to perform your administrative duties and give notice. Now, what's in my notice of special appearance? Hi, I am a creation of God, man. I am man, creation of God, not a man. Get rid of that word, the letter A, right? Chris, that treatise on arrest and false imprisonment that I just dumped in the channel there, you might want to grab that. Those of you that are new, that just joined us here recently, I put that treatise on arrest and false imprisonment, uploaded that into the channel there. I highly recommend that as your first go-to for reading. Once you get through that book, you'll be so enlightened. And you need to start committing this stuff to memory so that you can rattle this off no matter where you're at, including sitting in a jail cell, and you can grab a piece of toilet paper and write this stuff down on a piece of toilet paper. Okay? You need to have this knowledge. Knowledge literally empowers us. And if you don't have the power, once you have the power, you have to learn how to wield this power, the double-edged sword. Speak the law. Learn how to effectively defend yourself. Now, I know there's a lot of people out there that seem to think they know what they're talking about and what they're doing, and I've seen those very same people fall flat on their face when it comes to doing paperwork. And they got all this shit made up out there. Oh, you got to do this. You got to correct your status. You got to do repudiation. You got to get your birth certificate. No, that's all a lie. I'm telling you right now. And I'll challenge any one of those men to a one-on-one debate or even multiple. I destroy all of that garbage and I will expose them, including David Straight. And I'm sorry, brother. I've given you this information. You destroyed the document templates that I gave you and you lied to me about it because it came back around to me. And all this crap, David Straight has some knowledge. There's plenty of people like David Straight that have certain knowledge, right? And it all sounds good. Some of it's a half-truth, so this is the problem we're running into. Nobody's doing their due diligence and reading this for themselves. And this is one thing that sets me apart from everybody else out there. I show you the evidence, the law, the history of law. So, pretty hard to rebut what I'm saying. Because it's not my opinion, these are facts of law. You're arguing with facts of law, and you're going to lose every single time. So, now that we know about this notice, first step of due process of law, this is how we start to rebut the presumptions that's in the court of record that they have filed. Right? He who leaves the battlefield first loses. So we're in this court playing a game of tennis here. You've been served the ball, the paperwork. Are you going to respond? Are you going to hit it back? Or are you at fault? Are you leaving the battlefield? And again, the judge, the magistrate, who is supposed to be a disinterested third party here, he's the trustee. Virginia Declaration of Rights, June 12, 1776. I might even have that pulled up here somewhere. Imagine that. Right here. That magistrates are their trustees and servants, and at all times amenable to them. Okay. Amenable meaning demand for relief. To grant relief when it's proper before him. If it's not proper before him, he can't grant relief. because you didn't, it's not proper. And people sit here and bitch and complain, well, they're violating my rights, they're violating my rights. Put it in writing. Serve it to the party that's on the court. In the court of record. The judge is not a party to the case. Look at your documents. Who's it from? That's who you respond to, not the judge. The judge has to do a finding of facts and conclusions of law from the record. Now here's another thing. When these judges, magistrates, start entering facts on the record from the bench, no. You're not a party to the case here. Objection. You're trying to attempting to enter facts on the record that are not in evidence. They're not in the court of record. Well, Mr. and Mrs. Prosecutor over there failed to put that in the record. How did you find those facts? How did you find those conclusions of law that's not in the record? Okay, now let's go over to Rule 12. What are we talking about? That 2, 4, and 5, right? Defenses and objections. Imagine that. When and how presented. Motion for judgment on the pleadings. Consolidating motions. Waiving defenses. Hearings before trial. Imagine that. Let's take a look at these suckers. All right. Time to serve a responsive pleading. Now this is where we go back to the rules of the common law. Minimum is 20 days or 21 days, including the day of service. Okay? In general, unless another time is specified by rule or statute, the time for serving a responsive pleading is as follows. You got 21 days to respond. Okay? This stuff moves along real quick. It will leave you behind if you do not respond. A party must serve an answer to a counterclaim or cross-claim within 21 days. Okay? So when you file your notice of appearance and you do your motion to dismiss with an affidavit in support of the motion and then a brief memorandum of law with points of authority in support of the motion to dismiss, they have 21 days to respond. Let's say they do respond and say you're full of crap. I can prove it. And I rebut your response. Now you've got 21 days to respond to that. Because we're playing the game of tennis here. Party must serve a reply to an answer 21 days after being served with an order to reply unless the court specifies a different time. It's a game of tennis. You leave the court of record and fail to respond, that's by default. That's a default judgment. Now the other one, a lot of people talk about, summary judgment. That's if both parties respond, and then now, based on a summary of conclusions of law or facts, right? Findings of facts and conclusion of law. Where here's the facts, I demand a summary judgment. Can be granted. All right. Now, we want to get down to 12B. Every defense in law or fact to a claim for relief in any pleading, whether a claim, counterclaim, cross-claim, third-party claim, must be asserted in the responsive pleading if one is required. You're damn right it's required. If you fail to respond, silence is acquiescence. Where there is a duty to respond is the other part of that. You have a duty to respond. If you don't respond, you're acquiescing. Got to perform your administrative duties if you're going to claim your sui juris. If not, you're insane. You're not of sound mind. That's your only two options. You're either of sound mind or you are insane. You're incompetent. And you are a ward of the court, and you will be dealt with accordingly. But a party may assert the following defenses by motion. Remember 2, 4, and 5. are the key ones. Number 2, lack of personal jurisdiction. Number 4, insufficient process. Due process of law. Number 5, insufficient service of process. Were you properly served? That's a question. Now, here's another one. Failure to state a claim upon which relief can be granted. Right from the get-go if you start this. But remember, 2, 4, and 5 are at any time. And you have to have the notice of special appearance to challenge that. All right. So, failure to join a party, another action pending between the same parties at the same cause. Okay? Make no mistake, when we're doing our statement of facts, we're making claims that this man did this conduct, this action. This is the conduct of the other party when you're making claims. Also claiming your status as a man. I don't have to do anything other than the notices of special appearance. Now, I'll give you another analogy here, is that, okay, I'm the owner of Kirkschlock Corner LLC. I'm licensed as a 501c4 to provide news, education, and other services. One of those other services that I provide is a notary. I'm an Idaho Notary Public. Okay? I have, what's this here? Here's my license, right? Right here. Notary Public of the State of Idaho. Commission number, blah, blah, blah. To serve with all the rights and emoluments pertaining thereto. There's a status change, but that doesn't mean that I'm at all times a notary public. Only when I'm on the clock acting as a notary would anyone have a cause of action standing if I've caused harm to them. If I fail to perform my duties under the emoluments of my office. The emoluments are any advantage, profit, or gain received due to one's position of employment or holding of office. A notary public is an officer of the state, which comes from the common law as the go-between between man in the private and government, the public. That's what a notary really is. So, two different functions. Acknowledgement, that I have acknowledged this man standing in front of me and he provided some sort of identification to prove who he is, and yes, I'm acknowledging that he signed this paperwork. The other one is administering oaths. This goes back to the Fourth Amendment. No warrant shall issue but upon probable cause, supported by oath or affirmation. So, Elise, go ahead and put your question in the chat here. If you guys have questions, put it in the chat, and I'll get to a point here. Well, actually, I guess this would be a good spot to kind of pause on the documents, because now we're talking motion. Well, we don't do motions. Yes, we do. There is a prayer for relief here. That's where we make our demands. Let's see. Well, it's not really. These are not. See, criminal complaint really. I mean, this is your prayer for relief right here. Here it is. Therefore, plaintiff demands judgment against defendant as his liability appears in the sum of $10,000 together with the cost and disbursements. See that? Demand. Got to do the paperwork, folks. No ifs, ands, or buts about this. You cannot subvert your right to due process of law because everyone else has the same right. So you can't claim the that you're not that they're not following due process of law, but yet you're not following due process of law. That's not excusable neglect. Ignorance of the law is no excuse. Now, let's see. How do I stop the screen share? There it is. Okay. So let's open this up one at a time. Okay. Don't try to talk over one another. Anybody have any questions on what I've already discussed here?
But isn't a motion asking permission?
No. Motion is how you move the court of record. Putting it in motion. You have to serve the ball. We're playing a game of tennis on the court here. Don't you have to serve the ball and put that ball in motion? Answer the question.
Yes, that makes sense.
Say again?
Yes, that makes complete sense.
Right. And see, again, this goes back to the rules of the common law. I mean, I got the book right here in my hand. They're hiding it from you, but it's up to you to...
Where did you...
Go ahead.
The book, where do we get it?
Yeah, good luck finding this one. This one cost me $200 when I got it several years ago.
You don't have PDF one?
But I have this little fancy scanner over here that a man sent to me, and I thank you, Joel, for that donation. It's a really nice scanner. It scans books like nobody's business. I just turn the page and it keeps scanning. So there's other scanning stuff.
Perfect. So you can do
yeah.
PDF form.
Yeah, one of these days. But really, I've read enough out of this. I get it. And it's weird because in Latin, and you go from Latin to English and how they've kind of changed this, what I've just showed you from the Treatise on Arrest and False Imprisonment actually comes from the Latin, from the common law, on the pleadings and practice to do these documents. These documents are entitled directly from the Latin phrases of these documents. So any man out there who says, oh, well, we don't do motions, we make demands, they don't know what they're talking about. They haven't studied, and they have not learned how to do the proper paperwork and effectively defend themselves in these de facto kangaroo courts. So ultimately, my question here to everybody is, whose responsibility is it for our education?
Our own.
Bingo. So whose fault is it that we don't have this knowledge? Yep. I know. Step up.
Parents.
Step up, humble yourself, and admit that you don't have the knowledge and do something about it. Learn. Because, again, you step into the boxing ring and you don't know how to defend yourself, you are going to get beat up bad. And I'm speaking from experience, wisdom, got the gray hair to prove it. Silver, whatever. So, this works, and I know that it works because I've done it. And I've had other people do it. And again, there's a woman on here right now who helped her sister do it. Had relief in 2 days. Is that not true?
Absolutely.
Thank you. All right, let's see. Which is probably why why most everybody is here right now is to get some education, okay, from somebody who has experience, real experience, reading, and I mean reading. I don't know if many of you can really see back here, but there's a whole bookcase full of books here. Whole bunch of books I'm surrounded by books right here on my desks. I got another bookcase full of books over here. I know that may be pretty hard to see over there. Those are some Idaho Session Law books down there, over there in the corner. American Law Review, Annals of America, Chadman's Encyclopedia of Law. Okay. There's a whole bunch more down there. Whole bunch more over here. And I know it's probably...
Where at in Idaho?
in Boise, Idaho.
We're only a couple hours away from each other.
Say again?
We're only a couple hours away from each other. I'm in Missoula, Montana.
Oh, Missoula, Montana, huh? How's the snow up there?
Snow, it's actually wind right now, like I've never seen before. It's really weird.
Yeah.
Like, it's pissed.
Yeah. Well, you're a little bit further north of Boise, so I'm sure it gets bad up there. And of course, now my webcam's all wigged out. Okay, so any other questions before we move on?
Your screen went blurry.
Say again?
On my end, your screen's all blurry. I don't know if everybody else can see that.
Yeah, I just shut the camera
Yeah,
off and
it's
turned
blurry.
it back on. It does that. Okay, so now that we're aware of the notice of special appearance and the motion, right? Motion to dismiss, assert the grounds that I just showed you. And now I'm actually going to move over to the criminal rules of procedure because there are many different grounds to assert affirmative defenses. And these are the grounds, right? In any motion, what are your grounds for moving the court to grant you the relief that you're seeking, that you're demanding? Because justice is to be without sale, denial, or delay. And you have the right to demand justice. But it has to be done properly. You can't just spout things off. It's got to be in the court of record. You got to give notice and afford them the opportunity to respond. And you cannot speak about something on the record that are not in evidence. And if you're going against me and you file paperwork against me and we go to battle and we have to actually go in and have a hearing and you start talking about something that you haven't properly served me with, my grounds for the objection to silence you is attempting to enter facts on the record that are not in evidence. You didn't properly serve me with that. That could even be, you try and serve me with less than 21 days before the hearing. You can't talk about that paperwork unless I acquiesce. If I object on the grounds of insufficiency of service of process, you lose. You don't get to talk. And that's what a lot of people run into is, oh, he wouldn't let me talk, the judge wouldn't let me talk. That's because it's not proper before the court. It's not in the court of record. He can't see it, so he can only go and see. Fred Kelly Grant, God rest his soul, he just passed away here about a year and a half, 2 years ago now. 40 or 60 some years in, law. Of course, he's a member of the bar, right? But still, the stories that he's told, wrote a book called Justice My Ass. I have one here autographed by him. So, he says, the judge's hands are tied. Unless stuff is proper before him, they can't grant relief. Their hands are tied. And this is where my partner, before he got murdered, November 15th of 2020, softened my heart here a little bit about this, is that not all judges are bad. The thing is if you file the proper paperwork and assert your defense arguments, or what we'll call the merits, the grounds, and stick to just that, you're going to be more successful than you are now. I can promise you this. Keep calm. I know that fear and anxiety gets in there, and here's the other part of the trickery, is they try to get you all worked up. They'll make, especially like in the family law realm of things and CPS and all that stuff, they will, oh, well, that's hearsay, that's a lie, blah, 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 blah. They're trying to get a rise out of you so that you act out and prove that you're insane. You're not of sound mind. You can't keep yourself under control. You need somebody to represent you. And they will declare you incompetent. They'll send you over for a competency hearing. You got to go do a psychological evaluation because you're not of sound mind. You can't keep yourself under control. You can't remain in honor. And you can't calmly articulate and speak the law. So this is part of the twisted scheme, scam, and fraud. It's like, I want to help everybody. That's why I'm here. That's why I've been doing this for I started doing lives on Facebook and YouTube in January of 2017, a year and a half on Blog Talk Radio before that. Okay? I feel your pain. I've done it myself, so I know about the fear and the anxiety of going to court. But I can tell you, from my own personal experience, having this knowledge takes away that fear. And the more that you do it, the better you're going to get at it, and the less that anxiety that you're going to have. Okay? Okay.
I have a question.
Okay, go ahead.
I joined into this video chat late, but and I'm on so many Telegram groups. Is this group also affiliated with Dr. David Martin, that's trying to do that, serving all the attorney generals and the local groups?
Yes.
Okay. And also the schools for the CRT and the SEL and that?
Okay, so this particular live right now is about education, trying to teach people about the law, how to effectively claim, exercise, and defend your rights. So let's keep your questions.
Okay,
yeah.
Oh, okay, all right. I appreciate this. This video is really helpful too. So
yes,
great. Thank you.
You're welcome. Thank you. So this, this is at the root of everything, and they really try to mess us up in court. They make these false statements to get a rise out of us, and then when you try to stand up for yourself, right, call them liar and blah blah, you get all irate and angry, which anger is a healthy emotion. It's just about the actions that you take. And this is part of their trickery, is they trip you up and try to get you to act out so they can point the finger at you and say, hey, look, Judge, see how they're acting? This is what I have to deal with, and this is why we're here. They're crazy. They're nuts. They're insane. See how they're acting? But they don't look at well, what did you just do? No. Diversion tactics. Don't look at what I'm doing over here. Look at their conduct. Don't look at my conduct. And that's the other part is the judge isn't going to look at their conduct because there's nothing in the court of record for him to look at. He assumes whatever is in the record is true. Okay? So to remove the presumption, you have to do your paperwork. There is no other way around this. Okay? Now, this, actually, let's go back up here. This treatise on arrest and false imprisonment already has a memorandum of law right here. Now notice it's memorandum of law on arrest without a warrant, or without warrant. There's no A there. Now notice the case style. Upper and lower case. Upper and lower case. This is a suit between a man and man. Get used to this basic format. Okay, when you're talking about a memorandum of law. Now, you brief them on your arguments to support your claims that you asserted as grounds for the motion, whatever it is. Motion to dismiss, motion for default judgment, motion for continuance, motion to suppress evidence would be evidence was unlawfully obtained, fruits of a poisonous tree, unclean hands. There are doctrines here that are built off of the common law, God's law. For instance, those without sin may cast the first stone. Okay, let's translate that. Those with clean hands may claim a right to a cause of action. So, if somebody does something to you, that gives you standing to claim a cause of action. Now, the actions you take must follow due process of law. If you don't follow due process of law, you're depriving your fellow man of their right to due process of law, and now you don't have clean hands. You can't go into court like you've been out in the back pasture giving suppositories to cattle all day and come into court and assert these claims with your dirty hands and stinking up the courtroom. You're going to get thrown out. Okay? You've got to remain in honor at all times. Okay. Why does this keep jumping? Okay, something else going on there. All right, so we have these as document templates per se, right? Now, I'm going to go right back to the very beginning because this lays out some really good stuff. And again, I highly recommend, it's up to you to read this, right? It's up to you to educate yourself. This book is about liberty. It's about the lawful and unlawful, not legal. We're talking law, real law, by which government acts in depriving an individual of his liberty. History teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. Well, okay. If it's unlawful, how do you assert the claims that it is unlawful? How do you object to this? How do you assert your affirmative defenses, your grounds for dismissing this? This is what I'm teaching you. Okay? So, history teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. I don't think there's anybody here that could disagree with that. Especially if you've been subjected to the tyranny, to the corruption, to these de facto kangaroo courts. And I keep using those words because we have a government de facto. It's not a legitimate government. Gee, there's no personal jurisdiction over man. Plain and simple. No man has any authority over another man. Fundamentally and principally. Can you rebut that? No, you can't. At least, this is always the tendency of those who hold executive power. Daniel Webster once stated this problem in these words: "The contest for ages has been to rescue liberty from the grasp of the executive power." This is part of, in history, what we're talking about, separating those powers and creating three distinct branches of government versus two: king and parliament. Basically, it was the sovereign, the lawmaker, and the what would be the executive branch. That's it. They combined the legislative and executive. So, okay, liberty is taken away or deprived. Taken away. Theft. Theft of my property. Remember, property is an aggregate of guaranteed rights. So when they deprive a right, they're taking your right. They're stealing your right. Thou shalt not steal. Fundamental principle of the common law, God's law. All right. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrests and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills, which turn out thousands of new laws every year. The passion of modern legislatures to regulate, keyword, regulate, every facet of the most intimate concerns of everyday life is notorious. I'm sure a lot of you have felt this. This would be oppressive enough if administered under the requirements of a warrant or summons. Okay, pay attention here. This would be oppressive enough if administered under the requirements of a warrant or summons. Fourth Amendment does require that, and it's actually Article the Fourth, not Fourth Amendment. Okay. So yeah, this is part of what they talked about in the Declaration of Independence, subjecting us to pretended acts of legislation, blah, 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 blah. Fundamentally altering. Okay, folks. I really appreciate if you keep your chat comments to what's before us right now, because I'm getting a little confused about what's. It looks like you're talking about some other stuff that has nothing to do with this right now, and I know that lots of people on the group are probably responding to other things, but let's try not to pull me in a different direction. Let's stay focused on what's before the subject matter that's before us right now is education on your rights and how to effectively defend yourself. You can take this and apply it to whatever it is you want to talk about over there. But okay, and in many of the treatises on the law pertaining to the rights of citizens, and in many of the older and better court cases, we find the declaration that law is very jealous of the liberty of the citizen. What is the law that so regards liberty? It is the common law, and it declares that one who interferes with another's liberty does so at his peril. Imagine that. You deprive me of a fundamental right, it's going to be at your own peril, because I will hold you accountable. It also prescribes how arrests are to be made. Imagine that. Now see, they even have the little cases here, citations for that. That's what these little footnotes are. Number two, Knight versus Baker. But you already have all of this right here. This is already done for you. Somebody's already done the work. Okay? So, forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. Imagine that. Street Foundations of Legal Liability, Volume 1, page 12, citing Bacton's Notebook, Volume 2, page 314. See how this is proper citations. You're going to want to learn how to do research and how to properly cite your sources. Let's see. False imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing, by force or threats, an unlawful restraint upon a man's freedom of locomotion. The right to personal liberty is the right of the right of locomotion. Choo choo, vroom vroom. Okay, that's the power of locomotion. Remember trains, locomotive. Every
What
confinement.
are you reading from?
Say again.
What is this book or document that you're reading?
Is it what?
What's the book or the document that you're reading from?
Treatise on Arrest and False Imprisonment. It's in. I dumped the PDF in the chat there. It's for up above, so you'll have to scroll back up. Download that file.
Okay.
Let's see. So every confinement of the person is an imprisonment, whether it be in a common prison, in a private house, or in the stocks, or even by forcibly detaining one in the public streets. An arrest is a deprivation of your right of liberty. Any one of your liberties. Hey, you, stop. Do you got some ID? That's an arrest. What articulable and reasonable suspicion? Well, first, who are you? You need to properly identify yourself. This is where the statutes apply to them, because statutes are for government civil conduct. American Jurisprudence, Volume 16, Constitutional Law, Section 2, 2017 update. Statutes are for them. That's color of law. It only applies to those that are bound by it, those members or individuals. Article 6, Clause 3. So if they're a member of the legislative, executive, or judicial branch, both state or federal, they shall be bound by oath or affirmation to support this Constitution, because the Constitution. Okay, I'm going to ask this question. Let's see how many people can answer this question, and just put it in the chat. Is there any law that is higher than the Constitution? And I'll give you guys some time to. And what is that law? Remember, proper diction. There you go, Elise. Elise has got it. Law of nature. Okay. That is at the root of all law. But the actual term is called the law of nature. It is international law as the root for all law of nations, and it comes first. And you don't believe me? I'll show you from their code in Idaho here. Rules of evidence. Judicial notice. Or judicial knowledge. They're already supposed to know this, right? Facts judicially noticed. Ready? Facts judicially noticed. Facts judicially noticed. Courts take judicial notice of the following facts. Whatever is established by law, the true significance. the true signification of all English words and phrases and of legal expression. The true. Don't let them get away with these word salads. But here's it is. The laws of nature. Well, all be darned. The rules of evidence. Now, Idaho here, and the way they put this stuff online, here's the source. Oh, CCP of 1881. That's the Code of Civil Procedure of 1881, which is in the 11th session for the territory of Idaho. No, we don't do Code of Civil Procedure, where they took the Criminal Practice Act and the Civil Practice Act and combined it all into one code. No. And notice the year, 1881. Well, imagine that. That's the year that the statutes at large from England came out, extending the High Courts of Admiralty onto the land. Aside from the Congressional Act in 1845, extending Admiralty jurisdiction onto the land again. So, see how I provide evidence to support my claims? Facts judicially noticed here. I'm not fibbing, I'm not making this stuff up, and it's not my opinion. These are facts. Okay. So, back to doing paperwork, right? We have to do paperwork. There's no ifs, ands, or buts about this. You have to perform your administrative duties. And I may have to reopen that. Because I doubt it's going to let me. Nope. Yeah, I know. Okay, here's the law of nations, or principles of the law of nature, applied to the conduct and affairs of nations and sovereigns, with 3 early essays on the origin and nature of natural law and on luxury. Hold on a second, folks. I got a knock at the door. All right, give me a minute here. Mom is here. And I'm going to pause the recording. Okay. Always love visits from Mom. Uh-oh. Now what did I do? Does everybody still see the screen share all right, or is it like doing a split thing? There we go. Okay, so law of nations, or the principles of the law of nature, and it applies to the conduct and affairs of nations and sovereigns. Now, who are the sovereign? Sovereign citizen, right? Debunk the sovereign citizen, because citizens, technically speaking, give up their sovereignty in exchange for the emoluments of the office that they take. Right? I mean, we still have the basic rights, but it's a contract. You have specific duties to perform here. And that's exactly what you do when you make your demands, especially from the man who's supposed to be granting you the relief that's proper before him. You're demanding specific performance. He's bound by this, because that's what it says. And if not, he's impersonating a government official. But choose your battles, choose your arguments. Demand specific performance under the terms and conditions of his contract of employment. Either that or this is all fraud. Was there full disclosure that he's a foreign agent of a foreign defunct de facto government corporation that's already been foreclosed on, terminated, wasn't lawfully created to begin with? Read the book. Your answers to your question are right in the book. Are you talking about, oh, you're talking about law days. I was thinking you were talking about treatise on arrest and false imprisonment. Okay, I think it was like 18... There's 3 books in this book that's been compiled, and I know it was like early 1700. The third and final book came out just before 1770s. It was finalized. Right? Had to be broke down in parts. So I just, and again, this is another one you might want to dig into. I mean, I like going to Book 1, Chapter 3, Section 30, Section 34, so that you can grasp a concept of how to object to personal jurisdiction and subject matter jurisdiction. This books is a wealth of knowledge at the root of all law. When you know this stuff and you grasp the concept of hierarchy of law, what body of law stands on a higher plane, right? So this is where I go with anybody who wants to debate me and make their arguments and bring their evidence. Okay, you're going to need to provide some evidence that's higher than what the evidence that I provide. So if you cite some Idaho code or revised statute, and I go to the Constitution, or I go to a Declaration of Rights, that's a higher plane than the statutes than your code. So the code would be void for any effect, as repugnant to a higher law. That's just common sense, right? Book 1, Chapter 1. Let's get to Chapter 2, Chapter 3. Okay. I'll make this bigger so everybody can see it. This is Book 1, Chapter 3, subsection 30, page 93. Page 121 of the PDF. Okay. This section is of the support of the Constitution and obedience to the laws. The Constitution and laws of a state are the basis of the public tranquility. Okay, what does it say in the Constitution of the United States of America that was ordained and established? We the people establish justice. We the people ensure domestic tranquility. We the people provide for the common defense. Now, I'll answer this question a little bit later, because this provokes the question of, well, who are the people then? And this question and the answer to this question is without a doubt the most confusing thing out there. Got to change your status. Got to change your... No. Yes, but no. Not the way you think and not the way other people out there are teaching you. But this goes into Who are you? Are you one of the people? No, you're man, creation of God. And the first fundamental principles of the law of nature, primitive laws of nature, is when man is properly organized. So, when we come together and peaceably assemble, that becomes the sovereign body. Sovereign body, body of men, it takes the body. No one man is sovereign when we're talking about creating. That's why they go with sovereign citizen. Because they say, well, you're a citizen of the United States. And you're trying to claim that you're the sovereign, having the power to create when you don't. Now, when we're talking about the General Assembly, peaceably assembling and consulting for our common good, and we instruct our representatives, that's right, they're the servants, we're the masters. But this is the problem. We are not properly organized. We don't have our covenant and oath. Covenant is unto God, to uphold God's law, the law of nature, and nature's God, and assume the powers of the earth, dominion, and create government, institute, right? That to secure these rights, governments are instituted among men, receiving their just powers under the consent of the governed. Is a free inhabitant governed by that? No, because he's not bound by it. But a free inhabitant is considered part of the pool of men that can become one of the people by taking a covenant and oath. There's no firmer bond among men than an oath. God's law. So, if you're gonna become part of the sovereign body, you have to have your covenant to God to uphold God's law, and an oath to your fellow man to perform the duties as one of the people, and claiming your political rights, because political rights are not inherent in man. You have to have the contract, the bond. And I'm not talking about the bond as in, I'm talking about the love of bond. A sacred vow, like marriage, is a covenant unto God, and an oath or vow to your husband and wife, because marriage is defined, one, as a religious act, practice of religion. Number two, marriage, defined by God, is a sacred vow between a man and woman unto God till death do them part. And this is a union. You become one. So this invokes that cannot convert a right into a privilege, license it, and attach a fee to it. Murdoch versus Pennsylvania. They have unlawfully converted our right to the free exercise of religion, the internal dictates of our mind, liberty of conscience. That's what religion is. I think. That's religion. Oh, well, you got to be a part of a legitimate, established religion. No, I do not. That's a lie. I have the right to think for myself. Period. Can you rebut that? No, you can't. It's actually in Article 1, Section 4 of the Idaho Constitution, Declaration of Rights, under religion. Oh, but the liberty of conscience hereby secured. That's right. Secured. That to secure these rights, governments are instituted among men, receiving their just powers under the consent of the government. So let's read this. Public tranquility. The firmest support of political authority, policy, not police. It's pronounced policy. It's 3 syllables, and you look up the etymology of the word, what we say police, and you look at the timeline. and you'll see and compare it to the timeline of our founders and what they were writing in 1776, 1775, 1774 about erecting these multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance. This is what they're referring to. Look at the timeline. It's policy. Sound it out. Otherwise, it would be police, like head lice, or pole ice, like polar ice caps. There's no way to get police out of it. And the way they're doing it is, policing power, policy making power. Well, then it's pronounced police, right? Because it's policy or policing. No, it's policy making power, and policy does not apply to man. That's public law or man-made law. We go by the rule of law, not man-made law. So, and is security for the liberty of citizens. But this Constitution is a vain phantom, and the best laws are useless, if they be not religiously observed. The nation ought to then, pay attention here, again, pay attention. The nation ought to then watch very attentively in order to render them equally respected by those who govern and by the people destined to obey. To attack the Constitution of a state and to violate its laws, now, we're talking the Constitution, is a capital crime against society. Whoa. That's pretty heavy, isn't it? What's a capital crime? Sentence to death. Or to have your rights stripped from you. A civil death. You can't strip natural rights, but you can strip civil rights. And if those guilty of it are invested with authority, they add to this crime a perfidious abuse of the power with which they are entrusted. Now, here's something I want people to comprehend. At the time here, we didn't have our Republican form of government. It didn't exist. Monarchy, aristocratic republic, which would be close to the republic, or a democracy. That's the only three forms of government that existed at the time. Our founders read this stuff, read the Bible, and said, wait a minute. We're not supposed to have rulers over us. We're supposed to be equal. We're supposed to be free. We're supposed to be able to think for ourselves. This isn't how God intended our to be governed. Right straight from the Bible. So, they created a one-of-a-kind form of government. There is no other form of government on the face of this earth like it. It is the most liberating of mankind form of government. That it gets rid of those titles of nobility. We don't have kings, queens, and princes. We have public servants who are to serve the people based on the powers delegated to them. And if they usurp those powers, that is a capital offense, a capital crime against the society, the body of people. And it's a perfidious abuse of the power which they are entrusted. Key words here. The nation ought to constantly to repress them with its utmost vigor and vigilance. If you don't have any knowledge of how to do this, you ain't got no power. You ain't got no vigor or vigilance. How are you going to wield that power if you don't have the knowledge? Okay, I'll get to that. And it is Elise, right? Not Alice? Or did I pronounce that wrong?
No, you got it right. Thank you.
Sweet. All right. So, we have, right from our own readings of our own documents, we have free inhabitants, we have the people, and we have citizens. Those are the three statuses that we have here in this nation called America. This is the law of this nation. So all those other statuses out there that are people trying to tell you, well, I'm an American state national. That's not part of our Republican form of government. You're either a free inhabitant, you're one of the people, or you're a citizen. American state national does not exist as a status in our Republican form of government. Prove it. I can't seem to find it. And I've done a crap ton of research and reading over the years. And I mean a crap ton. There's somebody in here right now that can definitely vouch for that, who's been my friend for a couple of years now, who knows that I know this stuff, who knows because I've showed it. And that still can't even begin to show everything that I've read right here that's in my office right now. But that's the difference between me and a lot of these other people out there, is I've actually read, studied, weeded out the garbage, the fraud, and started figuring out, well, wait a minute, this is the legitimate parts of the law. Their code is not. So, see, I started out studying the code, what I thought was the statutes. And in fact, I didn't even hardly read our own state constitution until I got to the point where, wait a minute, holy crap, there's a whole bunch of good stuff here. Everybody's been taught the Constitution of the United States of America. You know, clear back to 1987 in high school for me, the civics, we were taught the Constitution of the United States of America. Bill of Rights. And actually, they really didn't teach us the Bill of Rights. They taught us the 14th Amendment, which, by the way, the 13th, 14th, and 15th amendments only applied, they were made for the freed Negro slaves. And I just posted this on Facebook, on my Kirk's Law Corner page, the reference to this from the Senate. Their own document that says the 13th, 14th, and 15th amendments were for the freed Negro slaves. There are no, I'm not aware of, maybe somebody is, maybe somebody else might be aware of, any freed Negro slave that is alive today. So stop claiming you're a 14th Amendment citizen and your right to due process of law from the 14th Amendment, when due process of law comes from the common law. And in fact, due process of law and law of the land are synonymous. They mean the same thing. Due process of law is the common law. The common law of the land. Not the law of the air, not the law of
You
the
should
water.
get Derek Gonzalez. Do you know of
Yeah.
him?
I'm very familiar with Derek. Derek and I had a nice video back in, I don't know, 2000, I want to say it was like 2018. But I'm not sure that he knows this paperwork. I'm not sure that he knows how to do this. I don't know of anybody else out there that's teaching how to do proper paperwork and how to effectively defend yourself. And stay away from all that shit made up out there.
Have you heard of John Little?
I have not.
He's teaching this kind of stuff.
He's what?
He's teaching this kind of stuff.
He's teaching notice of special appearance and motion to dismiss and brief memorandum of law with points of authority.
No,
Kurt.
No.
Oh,
It's the gist of it, though.
Yeah.
He's in Canada, I think.
Yeah. This is the problem. Nobody's teaching the truth. Nobody's teaching people how to perform their administrative duties, and putting this all together. Why it makes sense is because we're man. We're supposed to be free. We're supposed to be equal and have our own conscience. And if you're going to claim that you're of lawful age and sound mind, you have to perform your administrative duties. You have to do the paperwork. And that's not, people are teaching all this other crazy paperwork, causing you a distraction and making you think that you have to actively engage in all this fraud to get out of the fraud. And then you try to take that paperwork and use it in these courts, and they will lock you up. I know this not from my personal experience, but from was a friend of mine who got locked up out in New York. And David Straight went to go help him. And I told him, look, guys, you need to do the proper paperwork to do this. Oh no, I'm going to do my never perfect court affidavit, and we'll file that in there. And you know what they did? They moved him from the county jail into the loony bin. That's the problem. None of that is right. It's not in proper form. And you don't need all that fluff. Less is more. Short, clear, concise. This is not rocket science, people. This gets down to the root of, wait a minute, you're saying I'm this man over here, or this person? Person is a fiction. So governor is person. Lieutenant governor is person.
Right,
Okay.
titles.
Right? But it's a personifiance. In propria persona. In my proper person. Otherwise, you're man, creation of God. That's it. Now, here's the thing. Sure, mother and father are persons. Right? Persons have a duty. Now, when we're going to say mother and father are the sovereign to create their son or daughter, to create life. This is why our sons and daughters are a life interest. Some people say, oh, it's my biological property. Yeah, exactly. But it's called estate, chattel, property, properdiction, the words we use. And we have the right to demand our property be returned to us that has been unlawfully stolen from us. And I accuse that CPS worker over there of theft of my property, and I'm demanding my property be returned to me right now. That's ensuring justice. To no man will we sell, to no man will we deny right or justice. That's Magna Carta, 1215, chapter 39, or chapter 40, pardon me. That's how old that principle is. That we've, throughout history, have fought for this liberty, because that's what the Magna Carta is, the Great Charter of Liberty. Liberating us from tyranny and oppression. So, back down here. Most, right, the nation ought constantly to repress them with its utmost vigor and vigilance, as the importance of the case requires. Are you putting on the gloves, or like me, I take the gloves off? We're going to go into a boxing ring. You get no gloves for me, because the common law is ruthless. And once you learn this common law rules of procedure and pleadings and practice, and apply it every time to everything equally, you watch real quick how these people, I'm done, I'm out. They leave the battlefield. I've had many instances over the years now where I've never even gotten a court case because I've defeated them right there on the streets. And I start accusing them of the crimes that they are obviously prima facie self-evident as I'm recording them, and I'm accusing them of aggravated assault. Like one, we were out in Walmart after we had served lawful notification letters all over Boise. And one was at the Walmart there, and they called the cops on us, right? And then here's this guy that looks like he just threw I don't know if it was Boise Police or Sheriff's Department, pullover, sweater or whatever on. I think it was FBI, to be honest, because he pulled up in a completely unmarked black rig, It didn't say Boise Police. It didn't say Ada County Sheriffs. And then this other guy, one of the police, says, well, I'm going to arrest you and take you to jail. And I said, excuse me, what did you just say? Did you just threaten to kidnap me and deprive me of my fundamental rights here and throw me into a jail cell? That's right. I'm going to arrest you and take you to jail. Be advised, that is a threat of violence. And being as you've got some arms on you there, that becomes aggravated assault. And I'm accusing you of aggravated assault and a threat to kidnap me and imprison me without lawful authority. They all start kind of looking around each other, and they're like, that's right, I just accused him of a crime. With everybody else standing around, and we're videoing. Yeah, and then I started demanding their IDs. It's like, I'm not required to identify myself. You are. The statute that says you're required to provide a state-issued picture ID upon demand applies to public servants, so that way when you trespass upon our rights, that we can claim our right to a cause of action against you, and we require you as a servant to identify yourself with that state-issued ID as an employee, a servant. I'm the master here. Servants at no time get to dictate to their masters. So you go right ahead and play your game, but I'm good at this game too. And you take any action against me, there will be a reaction. I will claim my standing, because that's what gives you standing, is when your rights are trespassed upon. Now you got standing to a cause of action. Now it just depends on the actions that you take. Did you follow due process of law? The process that is due to them, which is a little bit different than the process that's due to man. When you're talking about a public servant, we can go directly in and file a criminal complaint against a public servant. We don't need to do notices, none of that, because the maxim of law is, one, ignorance of the law is no excuse. That applies to man. The second one is to know a thing and to be bound to know it are regarded in law as equivalent. That's Article 6, Clause 3, that requires every member of the legislative, executive, or judicial branch of government, both state and federal, shall be bound by oath or affirmation to support this Constitution, which that Constitution is the instrument of government that creates the protections of the real law, the law of nature. Okay?
But wouldn't that be on the legal side, as would what did you? I forgot what you said. Or in the complaint as well.
Okay. Try putting your questions in the chat, please.
Okay.
So, this is law of the land. The Constitution is the law of the land. Okay? So there's a process that's due to them because that's what they are bound by. And again, this all comes from the body of the people because the people are the ones that peaceably assemble and create the Constitution. Right? That to secure these rights, government is instituted among men, receiving their just powers under the consent of the governed. So, the Constitution is the law of the land. That has to come first. But what does come first is man. Gets properly organized, peaceably assembles, does a covenant and an oath. Now they become one of the people. Now, all of the people who have done their covenant and oath can come together and peaceably assemble, known as the General Assembly. Now we can institute the Constitution. We can institute government. We create that. The sovereign body create the Constitution of the people, by the people, and for the people. What is going on? Why does it keep doing that? No. A complaint is not legal. It's law. Comes right from the common law. Now, they've changed the Latin to English, and through English has been changed to the word complaint. Okay? Oh, I don't complain. Yes, you do. In the sense of what it really means. And yes, could be more of the barred word salad and changing the words from Latin to English. But yes, you can be the complainant. You could be the affiant when you're testifying. Okay? Okay, but claims are made within the complaint. See? I know. I've heard all of this crap over the years, and people are lied to and confused. Motions. We don't do motions. We make demands. We file affidavits. We make claims. We don't complain. Come on, people. No. This is due process of law that they are bound by. Okay? If you're going to be in this society or within the realm, the territory, and a public servant comes to you, he's bound by that stuff. You have to follow that living here. If you don't like that, move. But here, we have a written law of the land. And if you don't follow the process that is due, it is you that's depriving the right of due process of law. Because when they take that oath, they're stripped of that common law sovereignty to an extent, because they're under contract to perform specific duties. And they step outside of those duties to perform, you have to complain about it. Okay? Criminal complaint. I'm also going to take you down a little bit different path with a petition to the legislature for the redress of grievances. Okay? So I'll separate the two realms. Lawful and legal. Legal is contracts. Lawful is common law. Yeah, multi-million-dollar question there. So then what is the proper solution to have them all removed? You don't even have the basics down. And until you get the basics down and have the base knowledge of law, you're skipping way over your own head to try, I just want to remove, just teach me how to remove them from duty. But you don't have the knowledge to even put in the documents. How are you going to create the documents if you don't have the knowledge that goes in them? Quite a conundrum. It's a catch-22. How are you going to ride a bicycle if you don't know how to ride it? How are you going to put together a Chevy 350 engine if you don't know how to build it? You don't know the parts. You don't know all the components of the engine. You don't even know what all you need to put the sucker together to make it run. You're putting the cart before the horse. Well, that's what I've been trying to learn for 28 years. You know, comment here is that's what I've been trying to learn for 2 years. Well, I'm here to share my knowledge of 50 years on this planet and what I have discovered and what I have learned, and provide the sources of law to support it. And there it is. Everyone keeps pointing us in the wrong direction. Who is responsible for your education? You are. Do not blame somebody else. Ask them to prove it. Well, I'm an American state national. Can you show me where that is defined? Oh, well, that's in Title whatever 26 USC United States Code. That's all de facto government. It's not legitimate. It's not law, and that's color of law. Quit going to the fraud to try and seek a status that you seem to think exists because somebody told you. Prove it. What do you mean you don't know where to start? Holy Bible. Law of nations. Now I get that. I get that I was just as lost as everyone else here, right? No, man did not write the Bible. No. This was God inspired. Now, actually, I have that same argument, but it's different. Man has translated from Hebrew to all these other languages. So yes, there is a man involved in hiding, deceiving, changing meanings, right? But these are testimonies. Old Testament, New Testament. This is a testimony. They're books written by man, yes, as a testament, an affidavit. They're testifying to what they saw, what they experienced. This is their Tory, not story. Story is his Tory. It's actually Tory, T-O-R-Y. See, there again, messing with the English language to confuse the people. Okay. So, we're going to go back to this real quick. It is very uncommon to see the laws and constitution of a state openly and boldly opposed. Welcome to 2022. Welcome to 1215. Welcome to 1600s, 1700s. Okay. But this is before we actually started doing, some laying stuff down with declarations and constitutions. It is against silent and gradual attacks that a nation ought to be particularly on its guard. Gee, does this sound familiar from the Declaration of Independence? Something about the, the encroachments, gradual, right? Here's where I'm at. Sudden revolutions strike the imagination of men. They are detailed in history. Their secret springs are developed, but we overlook the changes that insensibly happen by a long train of abuses or steps that are but slightly marked. Now, this is what I've done. I've gone through history, historical documents, history of law, declarations and charters, and reading, so I get a better comprehension of the bigger picture of what we're saying even right here. Declaration of Independence says, but a long train of abuses. Gee, I wonder where they got it from. Right here. Here's the verbiage. It would be rendering nations an important service to shew from history how many states have thus entirely changed their nature and lost their original constitution. This would awaken the attention of mankind. Are you awake yet? Have you been awakened yet? Impressed thenceforward with this excellent maxim, no less essential in politics than in morals. Principius obsta. That's the maxim of law. They would no longer shut their eyes against innovations, which, though inconsiderable in themselves, may serve as steps to mount to higher and more pernicious enterprises. Okay? The Declaration for the Cause and Necessity of Taking Up Arms, July 6, 1775, talks about these pernicious practices. That the king chose his new council, and they entered in this pernicious project. This is what they were doing. Our founders back in the 1770s were talking about. They're fighting against this. And we're supposed to resist the first advances. Principiis obsta. Object to the principles, the morals, that they're in violation of the morals, right? Okay. Now I'm going to take you down here to 34 because this is so good. And I cite these off of, memory, the citations, and here I come back to it, right? Of the legislative power and whether it can change the Constitution. So there's a question that's asked here. You're welcome. There's a question that's asked here is, well, does the legislature have the authority to alter the fundamental laws or the Constitution? Remember, who is the sovereign, the creator? And does that which is created, can it alter the laws of its own creation? The answer is no. But let's read. Here again, a very important question presents itself. It essentially belongs to the society to make laws both in relation to the manner in which it desires to be governed and to the conduct of the citizens. Constitution and statutes. Citizens, those are members. And I'll take you down here and show you exactly the definition of citizen that comes from right here that our founders used as a definition of a citizen. This is called the legislative power. The nation must entrust the exercise of it to the prince or to an assembly. So, what our founders did throughout the charters in history, okay, throughout history, it's been the test of time to strip that executive power, right? This is it. They did it through overtime and said, hey, no. We've got our own legislative assembly over here, and we can take care of ourselves over here in America. You keep your English Catholicism over there. We're establishing Christianity over here. A whole separate, different ideology, separating from the Roman Catholic Church, starting with the Magna Carta. That's what's been going on in history for a long time. Trying to get away from Catholicism, the monarchy form of government, and get to where the people have the power. All political power is inherent in the people. Got to be one of the people to claim and exercise political power. Otherwise, you just stay as a free inhabitant in the private, out in the woods, and you mind your own business. And no part of government, what's been created, would apply to a man in the private. There's no personal jurisdiction over man because man has no personal jurisdiction over another man. So there's an objection to the personal jurisdiction. When any part of the government takes action against you, that's an immediate notice of special appearance, how I'm appearing as a creation of God, man. And if you're talking like family law, mother or father, that's in my proper person. That has rights and duties to provide for the care, custody, and control of your son and daughter. You have that power. No other man or woman on the face of this planet has a higher standing or right to the medical care, the custody, and control of your son and daughter because it's your property. So I'm going to object to any man out there or set of men who think they have some sort of power over my property. as while I'm acting as father or mother, and I'm gonna declare and claim theft of my property, and I demand my property to be returned. I've never seen a district attorney claim that they're the people. Never have heard that. Never. Now, I have had a sheriff deputy. Well, I'm one of the people. No, you are not. You are a citizen. Citizens are those that are bound. You receive the emoluments of that office. You give up your sovereignty in exchange for the advantages, profits, and gains of the office, the emoluments of the office. And then you're bound to perform specific performance to discharge the duties of that office, as we, the people, dictate to you by statute or by constitution. Or that the assembly and the prince jointly. So, got to be one of the people to be part of the assembly. Then the assembly electors. This is what qualifies you as an electors once you do your covenant and your oath to start with as man, common law. Now you're changing your status to one of the people and claiming your right to political power. The only way to exercise political power is through the sovereign body, properly assembled and a quorum. Then we can create the Constitution. And we delegate certain powers to the representatives based on the powers that are delegated. Those are called emoluments. Governor is an emolument. Lieutenant governor is an emolument. Secretary of State is an emolument. Sheriff is an emolument. Those are created by man. Because otherwise, none of that exists. Not in reality. That's all fiction. It's all made by man. Okay, I see that. The people of the state of California. Great. Let me show you. Article 5. Judicial Department, this Idaho Constitution. Section 1. Forms of action abolished. The distinctions between actions at law and suits in equity. See, this is where the change is coming from, folks. And the forms of all such actions and suits are hereby prohibited. And there shall be in this state but one form of action for the enforcement or protection of private rights or the redress of private wrongs. That's a lie, because you're subverting the laws of nature. And you're subverting the previous laws, which goes back to Article 6, Clause 2. Anything in the Constitution or laws of a state to the contrary, notwithstanding. Do the people have the authority to alter, which we're just right there, alter the common law, the fundamental law, or the Constitution? The answer is no. So we'll go back to that, but I want to show you. Which shall be denominated a civil action. No, that's right. When we're talking suits at common law, it is all civil. Now, whether or not, as in civilized, this is why we have the right to demand the nature and cause of action. Is this criminal in nature? Or is this civil in nature? That's suits at common law. Suits in law or in equity is Article 3, Section 2 under admiralty jurisdiction or maritime jurisdiction, maritime law. So, but people, I got myself into an Article 3 court. Oh, you put yourself into an admiralty court, huh? That's all of the courts of the United States. Every single court of the United States is an admiralty court. Didn't you know that? Didn't you read Article 3, Section 2? Where does it say common law in there? It doesn't. And in fact, the way our Republican form of government is supposed to work, we go to the legislature with grievances dealing with public servants. Or more specifically, the corporation. Okay, to provide oversight, we the people provide oversight. But see, we're not properly assembled right now. We're still dealing with government de facto. We don't have a government de jure because man has not been properly organized, done their covenant and their oath, and declared their status as one of the people, claiming political rights, political power. Okay? Now, every action prosecuted by the people of the state as a party. Now, I found in the Criminal Practice Act of 1864, the real statute, because see, this was being laid down before the Constitution to institute government, the statutes. It says it's supposed to be, the prosecutor is supposed to prosecute on behalf of the people of the state. So the prosecutor is not one of the people, but it's supposed to be in the name. What's the name of one of the, see, people? This is one of those words that's kind of trickery, because people can be, it can be singular or it can be plural. But we usually say, hi, I'm one of the people of the state of Idaho because I'm a notary public. I'm an officer of the state. See how that works? In order to go in there, to get elected as a representative in the House, you still have to have your covenant and your oath at the root here first. Now you can be qualified as an elector to be elected in as a representative. Then once you get elected into that particular position, you have to take another oath of office to perform the duties per the Constitution, the laws of creation of that office, against a person. Look at the words, right? Prosecuted by the people, of the people, by the people, for the people, of the state as a party, against a person, charged with a public offense. For the punishment of the same shall be termed a criminal action. Are we reading between the lines here? Okay, talking about the birth certificate. The birth certificate is fraud. And fraud vitiates everything, capital T, from its inception. Void ab initio. That's what void ab initio is. From its inception. So, this is objecting to the personal jurisdiction. That's the straw man. They're attempting. Okay, here we go. Comprehending the fraud here. Let's look at that. And by the way, I can't seem to find sovereign citizen in here. I've already defeated that sovereign citizen constitutionalist argument made by the prosecutor in Tony Pellegrino's case. The motion in limine, the defendant's attempting to make sovereign citizen and constitutional arguments before the jury. I responded and rebutted point by point every last part of it and demanded proof. When we got to court, which, by the way, I got to sit next to Tony up at the bar to help him as an assistance of counsel. But at first I couldn't because I didn't have a license to practice law. But then we filed some paperwork and put him on notice. And when it came time to go to trial, Tony asked, "Can I have my assistance of counsel?" "Sure, come on up. Come right up. Come right up." That's right. Judicial notice. Okay, let's look at this straw man, and so you can comprehend what's going on here. A front, a third party who is put up in the name only to take part in a transaction. Nominal party to a transaction, one who acts as an agent for another for the purpose of taking title to real property and executing whatever documents and instruments the principal may direct respecting the property, person who purchased property for another to conceal identity or real purchaser, or now here it is, or to accomplish some purpose otherwise not allowed. It's not lawful to convert man into person. It's an artificial construct. It's a corporate Ponzi scheme because, here we go, personal jurisdiction. We only give personal jurisdiction to corporations, not man. Government, per the Constitution, everything created under the Constitution. Where do you find man? You'll find people, you'll find person, but that's it. You won't find man. Won't be in there. Okay. So, to accomplish some purpose otherwise not allowed. So, the prosecuting attorney doesn't have personal jurisdiction over man. Suits between man and man are suits at common law. But see, right here on the screen, they try to say that, well, that's been abolished. Suits at law and suits in law are abolished because, well, this is trickery. Anything in the Constitution or laws of a state to the contrary are notwithstanding. This is void for any effect. How do you invoke the common law jurisdiction? By doing a notice of personal jurisdiction objecting to their shit made up. There's no personal jurisdiction here over man. Can they prove it? No, they can't. And this is where they will go silent, and they will leave the battlefield first. I promise you this. They will not respond, which is a default judgment. And you have to move your court of record and demand relief here. And they won't object to the motion for default judgment either. But once we get things going again, we'll actually end up with our own court seal, family court seal. And you can do your own default judgments and orders. Because every man is the manager and disposer of his own affairs. These are all kangaroo courts, ones that don't recognize rights. They don't even recognize the Constitution. So if they don't recognize the Constitution, where does their lawful authority come from? Because the Constitution is the law of creation instituting government, which that man is claiming he's sitting in one of those emoluments enumerated in the Constitution. Well, if I'm man, none of the Constitution applies to me. I'm not bound by it. Not while I'm in the private acting as man, a free inhabitant. I'm not bound by that. Now, that goes back to Cruden versus Neal, you know. Man is not bound by anything created by his fellow man. Man is only bound by the laws of nature. Imagine that. Yeah, just so everybody is aware, the Reconstruction Acts of 1871 have been nullified, made void. And I'm just going to give you a little hint. There's the report of the Commission on Unalienable Rights, and there's the 1776 Commission that Trump created. Okay? Trump said we're going back to 1776. We need to come together. We need to do our covenants and our oath, become one of the people, claim our status as one of the people, claim the right to political power, and fill those seats that everybody talks about. Oh, well, all seats are vacant. Well, technically not, because part of the deal there was to provide these essential governmental services. So they're there. It might be de facto because it's not completely legitimate, but it's not a representative, a legitimate seat in our Republican form of government. Yes, it is. It most certainly is. Is governor not a legitimate seat in our Republican form of government? Yes, it is. That is a legitimate seat, a legitimate emolument. Now, we can get into lieutenant governor, secretary of state, the treasurer. In my mind, those are still all legitimate seats in our Republican form of government. Is the president a legitimate seat in our Republican form of government? How about the military? A militia being necessary for the security of a free state. A militia. Not a police, not a standing army, no armed bodies of men. A militia. And we have three types of militia. The unorganized militia, unorganized by government. Then we have the state organized government and the federal organized militia, state and federal militia. We call that the military, an armed body of men, army, arm ye. Armed body of men is army. Another one of them pronouns. What's this? I'm wondering if the restored republic will be announced in public, or do we have to figure everything out and present it ourselves? When USA Inc. was declared bankrupt, are all laws under that corporation? Yeah, they weren't valid from the beginning because it was all void. It did not have the lawful authority to alter the Constitution, the laws of its own creation. The Constitution is a supreme written will of the people and is absolute and unalterable by the servants. Which goes right back to what I'm trying to show you right here. The nation must entrust exercise the Prince Assembly and the Assembly of Joint we have the right to make new laws and repeal the old ones. It is asked whether the power extends to the fundamental laws, whether they may change the constitution of the state. The principles, plus sign, minus sign, multiplication sign, and division sign. The principles we have laid down, declarations, led us to decide with certainty that the authority of these legislators does not extend so far, and that they ought to consider the fundamental laws as sacred. If the nation has not, in very express terms, given them power to change them, and we did not give them power to change the common law. We did not give them power over the fundamental law and principles of law. We go by the rule of law, not the rule of man. not color of law. For the Constitution of the state ought to possess stability. And since that was first established, right? Law is that which is laid down, ordained, or established. Look, laid down, imagine that. Established by the nation, which afterwards entrusted certain powers, certain persons with the legislative power. Persons. Okay, we have to create those persons. Governor, representative of the House, delegates. Those are all persons. They have to step into that and perform the duties, the actions. They're an actor. No. You got a public defender, you're a ward of the court, you're incompetent. You've been deemed insane. Nobody's going to listen to you. Stop hiring these foreign agents, members of the bar. Okay? No, not Marbury versus Madison. Okay? I don't go to case law. I mean, I can refer to some case law stuff, but it's the law of the case. And I'm not either Marbury or Madison, so Marbury or Madison doesn't apply to me. I'm not a party to that contract. How about Article 6, Clause 2? Anything in the Constitution or laws of a state to the contrary or notwithstanding. That's law of the land and a fundamental principle. We'll go back to common sense here. Anything that comes from the fundamental law, the common law, stands on a higher plane than any constitution, the law of nature. And anything in the Constitution stands on a higher plane than statutes. And statutes stand on a higher plane than any regulation or city ordinance. Hierarchy. Which one comes first? Oh, you did the proper paperwork and you filed a notice of special appearance objecting to the personal jurisdiction with a motion to dismiss asserting the challenges to jurisdiction and an affidavit in support of the motion, and then you served a brief memorandum of law with points of authority over to the other side. Because if you didn't do any of that, you didn't give proper notice and you didn't follow due process of law. Okay? That's what I'm here trying to teach people and, get this going to people. Oh, yeah. The restored republic. Yes, there is public notice. Oh, you bet there is. And this is the problem with certain groups out there claiming that they've done this stuff. That paperwork is not correct. Nope. And who are we trying to get away from for the ages? England, Great Britain, Catholicism. Why would I take a birth certificate and send it off to a non-Hague Convention nation state through somebody who has a blood oath bond to the Vatican and the Pope? Wait a minute, isn't that who we're getting away from? Isn't that where our birth certificates are stored, the long form, with our soul prints on it? Is at the Vatican. By the way, Vatican's been done raided, cleaned out. This stuff it's coming, folks. So, you have to do the proper paperwork. Again, it's all about the proper stuff. And this is very well kept secret because this is real deal. This is the real law and how it's properly done. And we don't want this stuff leaked out there. And in fact, I don't even have them yet. Not until we go into a closed room with a sufficient amount of people to do this. And we have to do the covenant and the oath first. Now we become one of the people exercising political power, and now we peaceably assembled. Now we're going to do some declarations, and then we'll publish them in the newspaper and afford opportunity, public notice, afford opportunity to respond and rebut or challenge. 4 weeks. Okay? There's some international law regarding the law of nations and how this is supposed to be done. And I've been looking for this stuff since about 2012. And I finally found it. So, back to this. Afterwards, entrust a certain person with a fundamental power. The fundamental laws are accepted from their commission. It is visible that the society only intended to make provision for having the state constantly furnished with laws suited to particular conjunctures, subject matter, and for that purpose gave the legislature the power of abrogating the ancient civil and political laws that were not fundamental, natural law. Civil and political. Like the right to keep and bear arms is technically speaking, a civil right. In our civilized society, our founders declared it is a civil right, and actually comes from the laws of nature, naturally, fundamentally, and principally, to defend ourselves from what may cause harm to us, and to shun the insane, to shun evil, to shun what may cause harm to us. But see, not everybody around the world has rights to keep and bear arms. But our founders made it very important that the reason why a militia is necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed by public servants. No subject matter jurisdiction. None. In fact, American Jurisprudence, Volume 15, Civil Rights, Section 2, natural rights and civil rights have nothing to do with the establishment, support, or management of government. There is no personal jurisdiction over man and his natural rights and civil rights, with the exception of certain civil rights as being part of or within the society, and of making new ones, right? But nothing leads us to think that it meant to submit the Constitution itself to their will. Here it is. In short, it is from the Constitution that those legislators derive their power. How then can they change it without destroying the foundation of their own authority? By the fundamental laws of England, the two houses of Parliament, in concert with the King, exercise the legislative power. But if the two houses should resolve to suppress themselves and to invest the King with the full and absolute authority, certainly the nation would not suffer it. And who would dare to assert that they would not have a right to oppose it? Of course we have the right to oppose it. So this is what our founders were reading and going, well, wait a minute, this is how it's supposed to be. Well, we're going to vest the power in the people. We're not going to put it in the king or the prince or governor. Because really, prince and governor was kind of synonymous. So they gleaned from the monarchy and created this brand new form of government. We're not a democracy. We're a capitalism, a capitalist confederate republic. Not a constitutional republic, not a representative democracy, not a democracy, not just a republic. You know, remember USSR, United Soviet Socialist Republic? Socialism? No, we do capitalism here. The true part of capitalism is the right to contract your labor as you see fit. That's right. and we are entitled to the entire fruits of our labor. That's capitalism. And because of my labor, I get to build my capital based off of my labor. Now, when we get into income, now if I'm making a profit off of somebody else's labor, that's an income. It's getting off in there, but taxes are voluntary and all that stuff. But we're supposed to pledge our lives, our fortunes, and our sacred honor. Okay, so now that we know that this is what makes void the Reconstruction Acts, because you can't subvert the fundamental law or the Constitution. You're under it, and you're bound by it. How then can you seem to think that you can alter it at a whim with an executive order? No. The pursuit of happiness is your right to think. So, your right to life, your right to liberty, freedom of locomotion to move around and do whatever you want to do. And the pursuit of happiness is your conscience. Okay? Property, again, is an aggregate of guaranteed rights. Among these rights are life, liberty, and the pursuit of happiness. But see, our founders already knew back then that our rights were an aggregate of property was an aggregate of guaranteed rights. This is why it's called a common law trespass, because they're trespassing upon our property. So here we go again. We talk about the Bill of Rights. Well, we have all these rights. We have all these. No, those are for the citizens, for the conduct. We live at common law in the private, suits between man and man, not suits between man and person. See, this is the real trickery. Oh, well, the Bill of Rights doesn't apply to the states except for by and through the 14th Amendment. That's a lie. That is a huge false statement, because that's just merely declaratory of the common law. Bills of rights and those merely declaratory of the common law, right, are mandatory. That's American Jurisprudence, Volume 16, Constitutional Law, Section 100, 2017 update. See how I know this stuff off the top of my head and I can just rattle it off? You have to know this stuff. Okay, so let's take a small pause here. One, I'd like to have a smoke break and potty break. But I want to do Q&A here real quick. I don't really see too many questions. Okay. Any questions? Comment?
I think September, she's been saying some things in the chat. Maybe September, you can unmute.
I got a question. I came in maybe a little bit late, but you've been talking about a proper way for us to have the proper status. Did you mention where we can find that information, or what we need to read to have the proper oath and get the proper status as a people?
I have not.
Yeah, that was my question too.
I have not gotten to that part yet, and I do intend to get there. So kind of like in a chronological order of things, I'll get to that.
Thank you.
So yesterday, the public defender challenged jurisdiction, and then I took over and I challenged jurisdiction, and it was personal jurisdiction. And the judge sat there and denied me the right to challenge jurisdiction. If I file a affidavit of sovereignty and a Ferretta waiver and then a motion to dismiss for lack of personal jurisdiction, wouldn't that close it all?
Okay. Did you file a notice of special appearance? Okay, go ahead and mute yourself over there while I talk so we don't get a feedback. Thank you. Did you file a notice of special appearance objecting to the personal jurisdiction? Yes or no?
Not in this case.
Okay, there's your first error. So the record is deficient of you doing any kind of notice of how you are appearing. So as of right now, they don't recognize you as Wu Man, having natural rights and the law of nature and invoking the common law, and that you're objecting to their person, the all capital letters name, that corporate fiction, artificial conversion of man into a corporation, corpse, a dead entity. Okay? So there's the first error. And then until you do that, you don't get to talk because you're not among the living. You're dead. And you need to be represented, which is the straw man thing. And this is how they're accomplishing this outside of what's lawful. It's a scheme, scam, and a fraud. Yes, I know. But you still have to do your paperwork and object to it. Because again, the court of record is your documents. That's in the record. And the other side, when they put their stuff in there, that's a presumption. They're presuming that that's who you are. Then the judge will assume from the court of record. And if your paperwork isn't in the court of record, he's going to assume what's in the record is true. Because you didn't give a notice informing who you are and how you're appearing. It's actually called pleading in the form of a demurrer. You're not pleading guilty. You're not pleading not guilty. You're pleading in the form of demurrer and objecting to the jurisdiction. That's the key words that they're talking about. They don't want you to know in the form of demurrer. But if you go to the federal rules of procedure and you read in there, you'll find pleading in the form of demurrer. Ooh, that's right. Okay, go ahead. September.
Yes. So the first step would be pleading, taking back, obviously submitting for personal or special appearance. Even though I have to sign the Ferretta waiver first, though, right? They have to go. The public defender. I was jailed, and the judge stated that until I allow the state to take over, I will be sitting in jail. So I was going to sit in jail, and then the next thing I know, the public defender has now the case. And when I talked to the public defender, they told me that it was because the judge didn't like what I had to say. And so yesterday, the public defender tried to get the judge to understand the jurisdiction issue, but now I get it. I just don't understand how anybody's supposed to get it when nobody's being made aware. I mean, if I was aware or given a choice, then maybe I would know. But it just seems like I'm just being used as property almost at this point. But so that would be the first step, though, right? I would have to get them out of the control of whatever's happening in the court. I'd have to sign a Ferretta waiver, right?
Negative. You don't have to sign anything.
Well, I haven't because I don't. Hold
on.
I feel.
Hold on. Don't talk over me, please. I listen to you. Now wait for my answer. So the thing is if there's no jurisdiction, that judge can't take any action and grant relief. So again, but see, the record is deficient in your notice of appearance and declaring your status of that I am man, woman, creation of God. So they're going based off of the paperwork that's already been filed, and not only that, that public defender, right? You're not in the public, so how can they be defending you? It's a conflict of interest. But they've done a notice of appearance, and they've done a general appearance and admitted jurisdiction. But see, this is the problem, because the first thing you have to file is a notice and informing them how you are appearing. And unless you do that, the record is deficient and you become a ward of the court because you're an imbecile, you're an idiot, you're a ward of the court, right? You're an infant. You're not of lawful age. You're not of sound mind. And clearly you're not perfectly capable of handling your administrative duties. So this is what they do. They will just ignore you, toss you to the side, and they have to appoint somebody to represent you because you're incompetent and you're disruptive to the decorum of the court. You can't talk about something on the record that's not in the record. If you're going to challenge jurisdiction, you have to give notice to the other side. Now, unless you're talking about right at the very beginning, they actually followed due process of law and took us before the justice of the peace for an initial appearance after making an arrest, not taking us to jail. They're supposed to take us to the nearest and most accessible magistrate, the justice of the peace, for breaches of the peace, which is either assault or battery. So there's the problem with your court of record. And they may even try to say, well, you can't challenge personal jurisdiction now. Really? Put that in writing. And why are you talking from the bench? You're supposed to be the disinterested third party here, not having a financial or otherwise equitable interest or any interest in the matter before the court. You're just a referee calling balls and strikes here. There's no objection here, so you don't get to make a ruling and give your opinion. I'm going to object to your interruption to me creating my record on the record. But again, you can't do that without paperwork. So you could go back to the notice of special appearance and just ignore what they say, right? They say these things to trick you. But unless it's put in writing and properly served to you, that's grounds for dismissing them for fraud, for depriving the right of proper service. You know, and I've said this, hey, you want to put that in writing and properly serve me? I'll respond to that. Otherwise, it's void for any effect. That ends that right there. And I just continue on with what I know that I need to do to create my record as evidence. So if I have to take it as an independent action outside of this, whatever I'm in, as an independent action, and now I become the plaintiff, I now have my court of record as evidence that I gave them notice. I afforded them the opportunity to respond. They never responded in writing because this has to be done in writing. They can say, oh, well, I said in court, well, who are you? Are you a party to the case? I don't see your name on any of this paperwork, and I don't see a notice of appearance from you. See how you flip that around? Where's your notice of appearance? How are you appearing here? I don't have anything in writing giving me notice, properly served. In other words, sit down, shut up, and perform the duties as I tell you to perform. You don't take any action unless I'm asking you to take some action. As king. Okay, over to you.
Kirk, if I have filed a notice of special appearance already with the court, when I went to do it, the clerk wouldn't accept it because it wasn't, did not fall into any of the forms. And I said, you have to accept it, even if, who cares if it doesn't go along with one of your coded forms? And they put it, they sent me over to self-help, and self-help said, oh, we'll attach it to this. And I did. And so I already have, I have on record of that. It just had to do with a different case. But, I mean, once it's on record, it should be on record, no?
No. No. How are you appearing in this matter? You have to create your record. Just because you, on a different record, that record doesn't apply to this record. See? This is the thing. That's a totally separate record over there. How are you appearing over there? And, I mean, was the document actually entitled Notice of Special Appearance? And it's a separate document from everything else. It is not to be combined with any other information. That's a yes
So
or no.
that has to be done every time.
Well, yeah. That's part of the initial pleadings. How are you appearing? How are you responding here? Are you responding pleading guilty? Are you responding pleading not guilty? Or are you pleading in the form of demur and objecting to jurisdiction or whatever, and providing your affirmative defenses, your grounds, and asserting those grounds for dismissal? You know, this is the thing. Every single time, at the beginning, that's the first thing that needs to be filed. And if you don't file that first, laches occurs. You know, dereliction of duty is your own fault. A lazy man loses. It's a maxim of law. You got drug onto a battlefield, and, well, you've been thrown in the ring, but you're not identifying who you are. The referee can't call on you. Who are you? You literally don't exist, except for on paper what they say that your status is, as a general appearance admitting jurisdiction. Silence is acquiescence. You know, that stuff applies equally to both sides, not just one side. These are principles. So principles apply equally all the time. And that's why I keep telling people the common law is ruthless, folks. Once you learn this stuff, you're going to start knocking them out of the park. All right.
I have two questions when you get a chance.
Okay, go ahead. What's your question? Start with one first.
Okay, the first one is my daughter is currently incarcerated based on circumstantial evidence, and she's been assigned a public defender. The bail has set so high that nobody can get her out. What would your advice be on getting her out?
Okay, so the one of the rights is right to writ of habeas corpus. Okay, for this particular situation right here, writ of habeas corpus says bring the body and bring your papers, and you better be able to prove why that woman is sitting in jail. Why it's such a high bail? Did they follow due process? Okay, so there's your writ of habeas corpus right there. It's an ancient right going back to 1215.
I've sent some documents to a federal magistrate
No.
who in turn assigned a federal case to my son, who is legally an adult.
Okay,
And
I've
he's
seen
disabled
your comments
and
out
still
there,
in high school.
right? This is part of the reason why I'm here,
But
right
I
here,
do
right
not
now,
know
today.
anything about the procedures of doing this. I don't even know what the task.
Okay, I've seen your comments out there, and this is part of the reason why I'm here today, trying to educate you folks on how this works. And I've answered your question. Writ of habeas corpus is the right. Okay? Now, your second question is about your son, and you're talking about some sort of, you filed some paperwork with a magistrate, and somehow that they've started a case for you. Okay? Well, you're going to have to learn. There is no quick learn here that this is going to happen overnight for you or for your son. Okay? Knowledge is power. You got to have this knowledge or you ain't got no power. And there's nobody out here that can do this for you. Trust me, I have tried. And the problem, and my buddy Tony Pellegrino, my brother Tony Pellegrino, we both have finally gotten to the point where we're pretty much done trying to help people in the help that they think and what they are asked. Well, can you just give me the document template? No, because you don't have the knowledge behind it. And all you're going to do is screw it up. And then try to go to court. You can't even argue what's in the paperwork because you don't know it. And then half the time we end up with people who, we give them a document template and say, okay, this is a template. Well, they go in and change like a couple names and they leave other stuff in the document from a different case. Don't even change the names down here. And it's like, no, not doing it. It almost seems like people, when they say, can you help me? What I'm hearing is, can you hand this to me on a silver platter and do it for me? That doesn't work. And that's my personal experience. And the same with Tony Pellegrino's personal experience. When it comes time to stand up there and make the oral argument, they can't do it because they don't have the knowledge behind the paperwork to begin with. Now, if you have the knowledge, that's a totally different story. But like you've openly admitted here in the group there in the channel, that you have no idea. This is all brand new to you. Unfortunately, right here, right now, today, the only help that I can provide for you is education. I can point you in the right direction. I can tell you about the writ of habeas corpus, that it's a right. I can tell you to go to uscourts.gov and download the writ of habeas corpus form that they have on there. Already done. All you got to do is fill it out. As for doing it for you, that's not going to happen. I've got way too much on my plate taking care of my own stuff, taking down all the garbage in Idaho, and I'm leading by example. I'm doing this. So when that's all said and done, I'll lay it all out. Show you the paperwork. But at this particular point in time, it's kind of laying low, keep it quiet, and just one little step at a time. Because this stuff takes time. Especially with what I'm doing, right? And when I come back from this little break, I'm going to go into a different right and a different process under this right. And getting back to political power right. Okay? So, I'm going to take a short break, and I'll be back. And feel free to talk amongst yourselves. If you guys come up with questions, put them in the chat there, and when I get back, I'll read them, and I'll address those first, and then we'll move on, okay? Be back.